Cahirlock, it's now 12 years since the enactment of the Defamation Act 2009, and although Section 5 of that Act required that a review be conducted, we're only now seeing the produce of that review. In fact, if you look at Section 5, it said that the review was to be completed within a year. However, I think we're probably in a stronger position that we don't have that review after such a short period of time. Because when you're trying to appraise the impact of a piece of legislation that's seeking to change how court cases and the legal system operates, I think you're better off waiting for a period of some 10 years. And so there's a benefit, I think, in the delay that has occurred. I should also say at the outset, Count Corla, that as a barrister, I have represented very many litigants who have taken cases in defamation, and I've also represented very many litigants, including many media organisations, who have defended cases taken in defamation. My involvement doesn't give me any more authority or any more influence in this debate, but there might be some benefit of the House hearing from a practitioner who has seen how that area of the law operates. I suppose it's also worth pointing out that it's hard for people outside of the legal system to understand the extent of defamation claims. I would have thought, although there are no statistics on this, that defamation claims amount for a very small percentage of the number of claims that are issued each year, either in the High Court or indeed the Circuit Court. I suspect they're less than 1%. Simply because they're a small in number doesn't mean that this is an area of the law that shouldn't be reformed, but I do think it's important to have perspective as to the incidence of these claims under our legal system. I also think it's important that we take into account the conflicting rights that arise here, because what this House is trying to do, what the Oireachtas tries to do, is we're trying to balance two conflicting Article 40 rights. On the one hand, we have the Article 40 right that each individual has to their good name. On the other hand, we're trying to balance the right that people have to freedom of expression. It's always the case that where you have two conflicting rights, there's going to be difficulty in determining which right on occasion should supersede the other. That, however, is the function of the legislature. We've done it in other legislation. I think of the tracing and adoption legislation that's going through the Houses of the Oireachtas. There also we're trying to balance two conflicting rights. I suppose it's also fair to say that when you listen to the public debate on it, probably more attention is given to the right to freedom of expression. And I say that not in any way trying to criticise the media. I perfectly understand and appreciate why the media will want the laws changed, and they may have a strong argument in respect of the changing of the laws. But I do think as observers we've got to recognise that obviously public commentary in the media is not completely objective, because there is a desire on the part of media to switch the balance more in favour of freedom of expression. I want to point out, however, recently I do commend, I think it was Una Mullally in the Irish Times, who recognised that fact. Even though she was advocating that there should be greater freedom granted to freedom of expression side of the Balancing Act, she did recognise that obviously as a journalist and as a newspaper, of course her preference was going to rest on that. I think it's important that we do try to look at how the right to one's good name also operates. The right to freedom of expression is very visible, it's very tangible. People have spoken about the fact here that we need to be able to learn vital information from the media or just in public discourse. That's a very obvious and pertinent point, and it's a point that needs to be emphasised. The right to one's good name is probably more nebulous, but the best example I can give to this House and to any members of the public who are listening is to recall what happened in this House and elsewhere back in 2017, 2016, when there were significant debates about what happened to a member of An Garda Síochána, Sergeant Maurice McCabe. We all recall in this House the reprehensible and dishonest and false campaign that was waged against him, and the statements that were made in the public domain about him, many of them which weren't broadcast in the media, but there was a whispering campaign in respect of him. The only remedy that man had in respect of those publications was the Defamation Act. I remember at times speaking to people and they expressed astonishment that there wasn't some criminal law in place to make it a criminal act to spread false rumours about another person, that that person had been involved in reprehensible criminal activity. There wasn't. His only remedy was under the Defamation Act. Obviously, he had a remedy in terms of his rights with his employer if his employer had breached his contract of employment. So I think it is something that we need to recall, that the right to one's good name, although it's nebulous, sometimes it's the only sanctuary that people have when they've been subject to a very serious campaign of defamation against them. I also think we need to recognise that, fortunately, in this country, we have a very strong and independent media. And Deputy Calleary mentioned previously about the excellent work that the media has done in Ireland in exposing wrongdoing in this country. I think it's also important to point out that they were able to do that, notwithstanding the defamation laws that exist in this country. And I think we need to recognise that recently Ireland was afforded 6th place by Reporters Without Borders when it came to places in the world for press freedom. So we do have a lot of press freedom in this country. I know the press want more, and I think we should change the Defamation Act to a certain extent. But we need to recognise that the media in Ireland is very strong, it's very trusted, and it's very reliable. When I look at an article in the newspaper, or I hear an article or a story broadcast on our media, I'm fairly satisfied if statement of facts are made in that it's true. But I think we need to admit that part of the reason we recognise and accept that it's true is because we know, because of our defamation laws, that the media wouldn't and couldn't publish it if it was false. So at some stage, I think we need to recognise that part of the reason why we have such a strong, effective media in this country is because of the fact that they're absolutely stringent in ensuring that the stories they publish about people are correct, that they're not false. And I think, just on an even broader discussion about trying to ensure that standards in journalism remain as high as they are now, we need to be careful about saying to the media at large, well, it doesn't really matter if you get stories about people wrong, you're not going to face any sanction in respect of it. Now, that doesn't mean that I'm not in favour of reform. I've looked at the report. It's a very detailed report, Minister, there, and there's a lot of very useful information in it. In terms of what I would assess as being the main issues in terms of defamation law at present, I'd say the following. First of all, where people are most subject to defamation, where most defamation occurs, is online. It's not in our, what would be referred to as mainstream media, for reasons that I've just explained. If somebody is defamed online by an anonymous person, in general now they've to go to the High Court on a rather tortuous journey in order to secure from the court a Norwich Pharma order. I welcome the fact that in this report it is proposed that a statutory scheme be put in place in order to ensure that every person knows what they have to do if they've been subject to defamation online. I also welcome the fact that the report has looked at the e-commerce directive. The e-commerce directive is far too soft on social media companies. They're not viewed as being publishers. They simply say to themselves, we're hosting a community here and we allow the community to state what it wants to state. It's sort of an Elon Musk type argument, which is a belief in absolute freedom of expression. I don't believe in absolute freedom of expression, and I don't believe anyone in this House believes in absolute freedom of expression. But we do need to recognise that when it comes to the e-commerce directive, we need to ensure that if a social media company is told that something is false and is defamatory and they recognise that and it's online, they have to take it down. I can understand why in the first instance there couldn't be a liability imposed upon them for the immediate publication, but once they're warned, they need to take it down immediately. I also welcome the proposal in the report, Minister, that says when it comes to offer to make amends, that there should not be a jury hearing that aspect. An offer to make amends, Cathaoirleach, is when a defendant makes a mistake. And I think we need to recognise that it's an occupational hazard in media or in journalism that people make a mistake. It happens in every walk of life. And if media make a mistake and they defame somebody by mistake, well then the sensible thing, and in most cases they do, put their hands up and say, we got it wrong. And that should be an easier path for them. At present, under the law as it is interpreted, although I don't think as it was intended under the 2009 Act, you still have the entitlement as a plaintiff to have that offer to amends heard by a jury. That should be changed. We hear a lot about the SLAP proposals that are going to be introduced. I welcome them. Nobody should use litigation for any purpose other than the stated purpose of the reliefs that are sought in that litigation. The only reason you should take a defamation action is because you have been defamed, your reputation has been reduced in the eyes of reasonable thinking people. So if there's a situation that somebody is taking defamation proceedings for a collateral cause, that needs to be slapped out. And I welcome the fact that the public participation part is emphasised. But I suppose when we talk about protecting public participation, it then brings me on to the issue of removing juries from defamation cases. Why are we seeking to remove the public participation of ordinary men and women in the country from determining whether or not an article or a publication has defamed an individual? And I think I can understand the reasons for why the media want to reduce it in terms of they believe it's going to reduce the length of cases, but I think I'd ask them to tread cautiously and carefully. If I worked in the media industry, I'd much prefer my viewers or my readers to be adjudicating on my work, as opposed to a judge then the Four Courts who probably hasn't read the paper before. But listen, it's an interesting report. I welcome the opportunity to speak on it, and I look forward to the bill. Thanks.